It's okay. Hello everyone. I want to thank everyone for being here. I apologize. I had a few technical difficulties and I deleted the link that was sent to everyone, and I can see how many viewers there are, and there's not a lot, so I'm just going to wait a couple of minutes while we get this link resent out so that everyone can log on and watch. And I am apologizing, it was my fault. I accidentally deleted the scheduled event. So I just want to thank everyone. So to people who are watching, I'm just letting y'all know that I accidentally deleted the scheduled event, and we are in the process of resending out the live stream event to everyone, and I'm just giving everyone a second to get it before I start the presentation. And I just want to thank everyone for your patience. Hi, I'm just going to make this announcement a few times, so I'm sorry if you've been on for a couple of minutes. I'm Lisa Everett. I'm a staff attorney at Houston Volunteer Lawyers. I accidentally deleted the live stream event, the scheduled event, and now we are live streaming. I am just giving everyone a second to get logged on, and then I'll begin the presentation. I can see that we have not as many viewers as I know had originally signed up, so I'm just going to give it a couple more minutes, and I appreciate everyone's patience. Okay, I can see that I think people are getting the link that my coworker Brittany has been sending out to everyone. I apologize because I deleted the scheduled event, and so now we are live streaming, and I'm just giving everyone a second to get logged on from the link that is being sent out. Okay, I can see that a lot of people are getting logged on. I know that we had a high sign-up rate for the CLE. My name's Lisa Everett, and I know I'm going to make this announcement just one or two more times. I accidentally deleted the scheduled event, and so we are live streaming, and I am just giving everyone an opportunity to get over here to the new link from the old link, and I apologize for that. Okay. Okay, guys. So I can see that we have over 100 people on, and I'm going to just start with the beginning because it's just housekeeping. So I want to thank everyone who signed up and everyone who came today. This is handling an eviction case during COVID-19, the CARES Act, the Texas moratorium, and requesting virtual hearings. And sorry, just 1 second. I'm getting notices that I should wait just 1 more second. And again, I really, really do apologize. Okay, I'm going to go ahead and start with the housekeeping section of this presentation. So first, I just wanted to introduce myself. My name is Lisa Everett. I'm a staff attorney at Houston Volunteer Lawyers. I've been here 7.5 years, and I help a lot of people with landlord-tenant matters. Today, we're going to be doing a very, very brief and basic introduction to Texas evictions. We're going to talk about the Texas moratorium, which expires next week. We're going to talk about the CARES Act. We're going to talk about forms and materials we have for you to use. I also wanted to let you know that if you are chatting, that it may take me a second to get to you. And I can see that several people have started chatting, and I'm going to say, yes, you are in the right place. So I just want y'all to know that, but I will try to keep an eye on the chats, but I may miss it, and I will go through the chats at the end of the presentation. I also wanted to let you know that we're going to be emailing these slides and some of the forms or resources I referenced to everyone who signed up. And I also want to let y'all know that the rules are changing quickly. I'm sure some of y'all heard that the Supreme Court issued the Texas Supreme Court issued new emergency orders last night. I'm being told by someone that there's an echo, and I'm wondering, and I'm just going to change a setting really, really quick. Just 1 moment, guys. I don't know if y'all are still hearing an echo. If y'all do, if you let me know, I would appreciate it. I will try to make this more pleasant for y'all. But I just also want to tell y'all that even though we're sending everything out, just keep in mind that things are changing rapidly. I had this presentation prepared on Wednesday, and I had to edit it last night because the Texas Supreme Court issued a new emergency order that changed that made me have to change the CLE. So we're going to get in. Thank y'all so much for letting me know there's not an echo. So when we start with the Texas eviction, there is one issue at hand, and that is who has the superior right of possession of a property or the premise. A landlord, when they sue for eviction, in addition to requesting possession of the premises, is allowed to request unpaid rent, and they're also allowed to request cost of court and attorney's fees if they have an attorney. It's really important that everyone know that there are no counterclaims allowed in eviction trials. That means that some of the things we're going to be talking today, like maybe landlords don't always have a right to file an eviction right now due to these special rules, but it doesn't mean that there are any counterclaims allowed because they are not allowed in evictions at all. but there are defenses, and we'll be going through some of those today. So the next thing we're looking at is the basic process of an eviction. First, there has to be a breach of the lease. If there's no breach of the lease, there is no grounds to bring an eviction. After there's been an alleged breach of the lease, the landlord can give a notice to vacate. After the period for the tenant to vacate has expired, if the tenant still has not vacated, the landlord is allowed to bring an eviction in JP court. When they file, the only way that the tenant can be served is by a constable. There are no private service processors allowed for evictions. It must come from the constable. If the constable can't hand deliver it after a couple of attempts, the constable goes back to the court, fills out a form, and gets authorization to leave the eviction pleadings on the door or with someone over the age of 16. Those are routinely signed, so someone cannot avoid process by not answering the door. After the person is served, there is a trial. If the tenant loses, if they do not appeal, then the landlord can get a writ of possession, and that's the process by which they are physically removed from the property. Or if the tenant appeals, then there's a de novo trial at county court at law. So the basic timeline, I just want to talk about times to appeal after the trial, because sometimes that's very important, and it's something that every tenant really needs to know, because a lot of tenants feel that the evictions didn't go as they were supposed to. So it's just good to know that the deadline to appeal after trial is 5 days. That is a strict deadline, and it includes weekends. In the event the 5th day falls on a weekend or a holiday, it does fall to the next business day. On the 6th day, the landlord's allowed to request a writ of possession. It takes a day or two for the constable to receive it, and when the constable does receive it, they go post a 24-hour warning, and that's the 1 day, this is the real deadline if the tenant hasn't moved out, that they have to move before they're physically removed. So now we're going to go into the Texas moratorium. And we're going to talk about 2 moratoriums. We're talking about the Texas moratorium and the Federal CARES Act moratorium. Right now, we're talking about the Texas moratorium. I will always try to talk about CARES Act or Texas moratorium because they are different. So going into the Texas moratorium. On April 27th, the Texas Supreme Court issued the 12th emergency order, which included halting residential evictions under the Texas Property Code and the Texas Rules of Procedure. I just realized, I apologize guys, that I accidentally skipped a slide. Part of the eviction basics is when you are looking at evictions in Texas, there are several places that you want to go to look, and you will get this in your slides. It's the Texas Property Code 91, which is just general information about residential tenancies. 92, which is more specific information about residential tenancies. 94, which concerns mobile home tenancies, and it's only mobile home tenancies. And Chapter 24, which is the eviction chapter. It's technically called a forcible entry and detainer, but everyone knows it as evictions. The other thing that's really important is that the rules of civil procedure for JP Court are governed by rules 500 through 510. And there are some important things in there, such as in JP Court, there's a rule that says the other rules of civil procedure do not apply. And it also says the Texas rules of evidence do not apply. And Rule 510 specifically concerns evictions. So if you're taking an eviction case, it's well worth it to look at rules 500 through 510, and especially 510. So, going back to the Texas moratorium. In any eviction in action for residential eviction under the Texas Property Code and the Texas Rules of Civil Procedure, the trials, hearings, and other proceedings were told until after May 18th. That is next Monday. Yesterday, I thought there might be a chance that the Texas Supreme Court might extend the moratorium. In the order that they issued last night, it is explicitly clear that the Texas moratorium is not being extended. So during this time, evictions have been allowed to be filed. The landlords have been allowed to file evictions this whole time, and many landlords have. It's just that there's been no service on the evictions. So it is very well, we know for a fact that people who have had evictions filed against them don't know they've had them filed against them because there hasn't been any service on those evictions yet. So next week, the constables are going to be allowed to go out and start serving these evictions. So going on with the Texas moratorium. During the moratorium, the courts were not allowed to conduct in-person proceedings, contrary to the guidance issued by the Office of Court Administration regarding social distancing, maximum group size, and other restrictions and precautions. The courts are supposed to be using all reasonable efforts to conduct proceedings remotely. I have the links to the Texas courts websites here. Our Texas courts websites were hacked and subject to a ransomware attack last week, and so their regular site has been down. Normally it's texascourts.gov. They do have a temporary website up, or while they're working to get everything working again. If you want to see the emergency orders that have been issued by the Texas Supreme Court, I have the link here. And if you want to see the court guidance issued by the OCA, I also have that link as well. And so one of the issues of the emergency order is that the courts are supposed to treat OCA guidance as mandatory rather than discretionary. Normally the guidance is discretionary, but the rule actually said they shall, or that they must not conduct in-person proceedings contrary. And so that's an important change. So what does it mean about the Texas moratorium? It means that tenants are going to start getting served next week because it's expiring. The OCA guidance says that in-person hearings aren't supposed to start until June 1st. So I do not believe there will be any eviction trials before June 1st, but you have to check each individual court website to make sure of that. Like I said, I believe that the OCA guidance is mandatory, not discretionary, but that's when we're expecting to start seeing the JP courts really reopen. The landlords have been able to file evictions during this whole time, and there's an existing backlog of eviction cases that were previously scheduled and canceled due to the moratorium, and then plus there's all these evictions that have been filed since then, and I think some landlords are going to continue to, of course they're going to continue to file since the moratorium has ended. Now we're going to get into the CARES Act. The CARES Act stands for Corona Aid, Relief, and Economic Security, and it was passed March 27th. I have a link to the actual law that was passed. The part that we're going to be talking about today, the eviction moratorium, is section 4024, and if you use that link, it's pages 212 through 214, and that's the temporary moratorium on eviction filings. So the CARES Act became effective immediately in regards to section 4024, which was March 27th. It expires after 120 days, which means that it expires on July 24th. It's really, really important that when we're looking at the CARES Act that you know what it applies to, and it's to covered dwellings and covered properties. We are going to get into that later on because it's really important. So during the moratorium, a landlord may not give a notice to vacate for non-payment of rent, and the landlord may also not file an eviction for non-payment of rent, and the landlord is prohibited from charging late fees, interest, and penalties related to non-payment of rent. Just keep in mind this only applies to covered properties. After the moratorium, i.e. on or after July 25th, the landlord may give a notice to vacate, but it has to be at least a 30-day notice to vacate. So here I have actually pasted the exact text from section 4024 about covered dwellings and covered properties. I'm not going to read it to y'all right now because we're going to talk about it more in just a minute. I hear a lot of people saying there's an echo. Okay, just one second, guys. I'm going to take a quick pause to try to figure out what's going on with the echo. I don't know what happened. I didn't change anything. People say it got better. I don't know why, and I'm sorry about that. So let me know if it happens again, guys. Thank y'all for letting me know. And just so you know, y'all are on a delay, about a 10-second delay, so thank you. Okay, so we're on the covered dwellings and covered properties. I'm not going to read this to y'all, but I do encourage y'all to read it. I'm going to review what it says in a second. So what it says is that a covered property includes federal housing programs covered by VAWA. VAWA is the Violence Against Women Act. We often think of it in terms of immigration, but certain housing programs are subject to VAWA rules, and those housing programs count as a covered property under the CARES Act. I have a whole list here, and I'm not going to read them to you, but I'm going to point out some of the ones that we see a lot in Houston, and that includes public housing. Those are housing communities owned by housing, like the Houston Housing Authority. The Section 8 Housing Choice Voucher Program, which is when people have a voucher that allows them to go to any private landlord in the market and get sorry, I'm reading your comments, guys. So it's when they have a voucher and they can go to any private landlord in the market, and the housing authority pays a portion of their rent based on the tenant's income, and the tenant pays the remainder of the rent. And those are very common in Houston. There's other housing as well, but I'm going to go on to the next page. It also includes, I'm going to highlight the one that I think is important. Whoops. I'm sorry, I skipped, guys, is the low-income housing tax credit. That's the last one on this list of what is a covered property. And that's a tax incentive. They get a IRS tax break. And there are a number of LIHTC properties in the Houston and Harris County area. If you want to actually see the sites to the code, if you're like me, you like to know how it's connected, if you click on this link from the National Housing Law Project, it actually cites how each program is connected to the VAWA program. And someone's asking, where can you download the PowerPoint? It is not available for download yet, but it will be emailed to everyone who signed up. It's also going to be available in the HVL volunteer portal. So what else is a covered property? A covered property also includes any property with a federally backed mortgage loan. These include HUD loans, USDA loans, Federal Housing Administration loans, VA loans, Fannie Mae, and Freddie Mac. I know that when this first came out, we heard Freddie and Fannie all the time. It is more than Fannie and Freddie. This is the definition that's given, and I'm not going to read it to y'all either, but I just want to point out that it is more than what's listed on the page before. So there's a Congressional Research Service report that says there's roughly 12.3 million rental units in America that have federally backed financing, which represents about 28% of renters. In addition to that, there is other data showing that there's more than 2 million housing vouchers, along with approximately 5 million federally assisted rental units. That long list that I didn't read to y'all, it's those. There is some overlap between these two, but we can see from these numbers it potentially affects more than 1 in 4 people in America who rent. So, what we want to talk about is protecting tenant rights, and like whether or not they know they're protected, and also whether the landlords know. So how does a tenant know if the rental unit is a covered property? Unfortunately, a tenant may not have any way of knowing if they rent a covered property. And this is especially true for the federally backed mortgages. And we're going to get into why. So, and I'm also going to talk about how can a tenant know if they are in if they're in a covered property because they participate in a housing program that is subject to VAWA rules. I can tell you that tenants who have vouchers, Section 8 vouchers, or tenants who live in public housing, they know that they have a voucher, or they know they live in public housing. However, just because they know they have a voucher or live in public housing doesn't know that they mean that the rules actually apply to them. And so it's an issue of one, knowing that the rule exists, and then two, knowing with that rule what it means. And I can tell you from personal experience, other people who receive other types of rental assistance or receive like below market rent may not know what program actually covers that portion of their rent. And I've seen that with people in housing for people with disabilities. I've seen that for housing for the elderly, and I've seen it in other instances as well. So sometimes tenants know they're getting assistance. Oftentimes it is through a HUD program, but they may not know the name of it. And HVL can help them figure that out, just so y'all know, some of the time. Just so y'all know, the LIHTC properties, you can tell if a property is a low-income housing tax credit property if they use the standard TAA lease, the Texas Apartment Association lease. On the addendum page, it will say that they have the affordable housing addendum, and that means that it is a low-income housing tax credit property. So why don't the tenants know sometimes when they're in a covered property? For a number of properties, only the owner is allowed to access databases that can tell you if you have a federally backed mortgage. There are ways for people to find out, and we're going to get to that in a little bit, but it doesn't cover everything. These websites generally require the use of a social security number or a tax ID number, along with a confirmation that the user is the owner or the agent of the owner or has the consent of the owner to access the information. So this is the checkbox that you have to sign if you go to the MERS website that says like 10 different ways that you are the owner, you have the consent of the owner. Y'all will get these slides, so I'm just going to skip to the next one. This is a screenshot from the Freddie Mac website for an individual homeowner. There are multiple search tools for seeing if Freddie or Fannie or someone else has a mortgage. And it's different depending on whether it's a 1 to 4 unit property or if it's a 5 or more property. This is a screenshot from the 1 to 4 property. And so it requests, you can see it requests the last 4 digits of a social security number. And then it has the verification box that says that by checking the box and clicking the button to submit the information, you confirm that you're the owner of the property. So a renter obviously is not the owner, and most renters are not going to have the social security numbers of their landlords. So I just want to point out that this is especially true for people who rent homes or rent in a duplex or maybe a quad. These are the people who can't tell if they're in a covered property by the federally backed mortgages. So now we're going to go into ways a tenant might find out if they are in a covered property, and also how we can try to look up to try to tell people if they're in a covered property. There is a database or a list that's being circulated from the National Low-Income Housing Coalition, and I have a screenshot of it on the next page. It's not comprehensive for multifamily residences, and it does not include any properties with 4 or less units or the single-family homes. There is a database for LIHTC, that's the Low-Income Housing Tax Credit. You can look that up by state, city, county. That is a good list. Sometimes you can check the real property records. In Harris County, we're lucky that we can look at a lot of real property records online. However, it may not indicate that the service or lender is connected to the federal government. And so the property records aren't necessarily the best way of knowing if a property is a covered property. If you are, these are the links to the Freddie and Fannie Mac links, and this is for the ones that are the multifamily units. Those are the 5 or more units. You can look that up on Freddie or Fannie Mac, but like I said, not for the single owner. But these 2 links here for the Freddie and Fannie Mac, this is when it is 5 or more units. You are allowed to look it up as a non-owner. So this is the screenshot from the National Low Income Housing Coalition, and it's for everything in the country. I did a screenshot of the zip code search for 77002, which is downtown Houston, and you can see that several properties did come up, and it says the source. So you can see that City View Lofts has a Fannie Mae, is connected to Fannie Mae. Houston House is connected to FHA, which is the Federal Housing Administration, and there's several on here. And so if you use this tool, the link is on the slide prior to this. You can search by city, but it's also really easy to search by zip code. So today, before we get into how to help people, I just want everyone to know, I've talked about moratoriums when evictions trials aren't happening, and that these, there's protections under the CARES Act for people who are in covered properties for the non-payment of rent. I don't want anyone to walk away today saying, I said that you didn't have to pay rent, because tenants do have to pay rent. None of these moratoriums excuse the non-payment of rent. However, there's also nothing preventing landlords from working with tenants to reduce rent or allow repayment plans. Some landlords are waiving late fees and interest because they know that some of their tenants are struggling to get caught up through no fault of their own, through loss of wages and employment. I want everyone to know that if someone's asking you what they can do for help, they can call 211 to find rental assistance for where they live. A lot of the agencies around town are zip code specific, and so if they tell the people at 211 their zip code, they can give them a referral to the agency that may be able to help them for where they live. And I'm sure a lot of you know that the city of Houston passed an ordinance about a week ago offering $15 million for rental assistance to city residents. They launched it immediately. Last week, landlords had to sign up. In order to be eligible for rent assistance through this program, your landlord had to be a participating landlord. And they opened it up on Wednesday at 10 o'clock, and at 10:30 they had run out of money. And I know that some of the money was going to the administration, but $14.4 million was gone in an hour and a half. And so we know that there's a huge need for rental assistance. And I just want to point out that people are still having issues getting unemployment and other assistance. I've linked to an article here from the Dallas Morning News that was published a couple of days ago about how people, maybe if they're approved for unemployment, they're still not getting payments, or there's a problem with the payment processing. And this article also said that the Texas Workforce Commission is receiving 1 million calls a day, which is down from the 1.5 million a day it was getting a week ago. A lot of people can't get unemployment because they can't get through. There's such a huge demand. So, a couple other issues. We know that some landlords are trying to do self-help evictions, which are illegal, and they're doing this by locking people out and not giving them keys as they're supposed to, or doing utility cutoffs. There are some pro se resources at the Texas Justice Center Training Center for the self-represented litigants, tenant remedies. There are some forms available. If we haven't had anyone come to us for assistance with that, but we know it's still happening. I've read the papers. I know some landlords are doing this. I hope that they don't. I also just wanted to talk a little bit about other Texas jurisdictions. Some other jurisdictions around Texas have passed jurisdiction-specific protections. Like the city of Austin is requiring landlords to give a 60-day notice to vacate for people who have lost wages because of the pandemic. And the city of Dallas has halted evictions for unpaid rent through May 30th, so past the Texas moratorium, and it's requiring landlords to give everyone a 20-day notice for all evictions, and if the tenant says that they can't pay because of COVID-19, then they're given an additional 60 days. If you go to this link at texaslawhelp.org, it has a list of all the various protections around the state, and you'll notice if you do look at it that there are no special protections for Texas or Harris County. So if you've heard about things in other cities or other areas, it does not apply here. So to everyone who is attending today, thank you. And I hope that everyone will commit to taking a case and helping someone who's had an eviction filed against them. And we're going to go into why in just a second, and we are going to discuss the emergency order that was issued last night. So once there's an eviction on your record, it can make it really difficult to find a new place to rent. Some apartment complexes will not rent to a person who's ever had an eviction filed against them. Some will rent as long as you can prove you don't owe money anymore. So maybe if you won your eviction or if you show that you paid the landlord, maybe they'll rent to you. But different apartment complexes have different rules and different landlords have different rules. But having that eviction just filed, whether or not you win or lose, just filed against you can make it really difficult for people to find new housing. Generally speaking, HVL does not accept non-payment of rent cases. And that's because, generally speaking, there's not really a defense for it. HVL's decided to take non-payment of rent cases, eviction cases right now, because we want to make sure that the law, and I'm talking about the CARES Act, is applied and that the tenants receive the protections available to them. And I just also want to clarify that we're talking about residential tenancies here. So, sorry, I'm just checking a couple of the links. Someone asked if I could link to the Dallas ordinance. If you use that Texas Law Help link, it does link to the ordinances, just so y'all know. And it links to the sources. And someone asked about, is there a way to start from the beginning? This is being recorded, so you can watch the entire thing from the beginning. Okay, so why do tenants need your help? As attorneys, if you're attending today, you are now informed, and it is our duty to help give good information and set realistic goals and expectations for clients. This is also how we can help them. I said we're taking non-payment of rent cases, and we know that, more than 1 in 4 people in America are in a covered property. And I have a slide on it in a little bit, but we also know that some of these apartment complexes that we can find on these lists have been filing evictions. So we know that landlords of covered properties have filed evictions for non-payment of rent since the CARES Act went into effect. But we also know that not everyone is covered. And so it's our duty to let people know that rent is still owed. And if they're not in a covered property, they're most likely going to be evicted. The tenant should know this so they can prepare. If we're helping someone, we need to let them know that even though we can try to help them, if they lose, they will have to move. We can help give them a timeline of how long they have until a constable can remove them so they can make preparations. And also, if you're helping someone, there's nothing to prevent us from trying to work out something with landlords. Some landlords will work with you. It needs to be in writing, but some landlords will work with you, and we can try to make that happen. And also, another thing that we can do is, whether a tenant is in a covered property or not, we can still make the landlord prove their case. Was there a breach of the lease? Did they give a notice to vacate? We can still make them prove their case. So tenants need your help because they deserve to have their rights protected. Some of the things that we're going to talk about in a little bit, none of this is done for delay. This is to ensure that the law's intended protections are administered. And I also just want to point out that landlords have some protections as well. If a landlord has a federally backed mortgage, there are protections in the CARES Act for them as well. I do have a link to the Consumer Financial Protection Bureau about some relief options available to mortgage holders. So I just wanted to point that out as well. And the real reason why tenants need help is because landlords of covered properties have filed evictions for non-payment of rent. And so we just need to make sure that in the event that the courts aren't stopping it, that we can help stop it. So last night, the reason I had to re-edit this presentation is because the Supreme Court passed the 15th emergency order. It was signed and published yesterday. And it says that for eviction proceedings filed from March 27th through July 25th, that is the moratorium period of the CARES Act. It says that for every residential eviction in Texas, that the landlord, the sworn petition that has the description of the facts and grounds for eviction, that's straight from the Texas Rules of Civil Procedure, must state that the premises are not subject to the moratorium on evictions imposed by Section 4024 of the CARES Act. And this link here, I know it looks really funny, but that is the direct link to the 15th order. You can also access it from the Texas Court's website from a previous slide. So we're going to talk now about how you can help volunteers, or excuse me, how you can help tenants, what we have available to you, because I want everyone who's doing this, we're expecting, because tenants are going to start being served for the evictions that have been filed next week. We have resources available to you so that you can take an eviction case and help represent someone. We have drafted a motion to dismiss with a notice of hearing and order. The basis for this is a lack of jurisdiction and baseless cause of action and this is for when we know the property is a covered property under the CARES Act, because the landlord does not have the right to bring that eviction under federal law right now. You'll need to add some sort of proof as an exhibit. Before yesterday, we were planning on offering y'all special exceptions with a notice of hearing and order. And the special exceptions was meant to be to request that the judge make the landlord file a pleading that asserted that they're not covered by the CARES Act. The Texas Supreme Court order has taken care of that for us. No one should have to file a special exception because the Texas Supreme Court has said that every eviction filed. I don't know how the courts are going to do that for the evictions that have already been filed. I don't know if they're going to call them before they come and say, hey, you need to bring this or we're going to have to dismiss it. I don't know if when they show up, if they're going to reset it for a week. I don't know how they're going to handle it, but the Texas Supreme Court should have taken care of this. I saw a question that says, do we know that the constables will be serving citations next week? I have not called around to the various precincts, but I believe that it's going to start next week. It has to start sometime, and it's allowed to start after May 18th. How do we know that the property is covered? Through discovery. The question is through discovery. Just so y'all know, under the rules 500 through 510, which covered JP Court, there's an explicit rule that says you cannot serve discovery on another party without permission of the court. If you do serve discovery, you can be sanctioned. That doesn't mean that you're completely prevented. You're allowed to request permission from the court to serve discovery, so it is an option, but that has to be ordered by the court as well. If a court doesn't order it, I think there are due process concerns if they don't allow the case to be proven in another way. So we're going to keep moving on. Resources available to volunteers. So we also have a motion for a virtual trial with a notice of submission and an order. I know that the JP courts are working to try to figure out how this is going to work. I don't know how many of y'all have been to a JP court docket, but they tend to be really large dockets. And under everyone's current health concerns, I don't think that people want to be into crowded courtrooms. I also don't think that JPs want crowded courtrooms, and I don't know how they're going to manage their dockets. But one of the options that I understand they're all supposed to make available to people because of the OCA guidance, which is mandatory under the Supreme Court 12th emergency order, says that virtual hearings should be made available. If I were you and I wanted a virtual trial, I would call the court first to ask how to get it. And if they are non-responsive, then we do have this motion for you. We also have a motion to refer cases to mediation with a notice of hearing and an order. I'm going to talk about mediation a little bit. I know that that can be very difficult to get ordered by a JP court, and I'll tell you why in a minute. But just so you know, we still have sample agreements, like an example, like an early move out or a repayment agreement, and you can use these for formal and informal alternative dispute resolution. And we also have a small packet on how to appeal using a statement of inability to afford payment of court costs or an appeal bond. Virtually every HVL client would qualify for this, which means they don't have the money to pay the appeal bond, which means that they perfect the appeal by filing this 2-page document that is promulgated by the Texas Supreme Court. If you're representing them on appeal, it would be accompanied with a legal aid certificate. That is how you appeal an eviction in JP court. You file that statement if you qualify. So, what can you do for people? You can make them prove the case. I am going to switch over for just a second, and I'm going to show y'all the the actual section of the CARES Act that applies. So just one second. I know it's only going to show on part of the screen for a second, but we're just going to go over it really quick. So when we are up here, this will also be emailed to everyone, although I did include a link. It says that a covered property means any property that participates in a covered housing program as defined in section 41411A of the VAWA. And so what means, the way I read this, is it means that if a apartment complex receives a Section 8 voucher from one of its tenants, then it means that the entire apartment complex is covered. And so if we are going to court with someone who, whether they've submitted this pleading already or not, in accordance with the 15th order from the Texas Supreme Court requiring landlords to state they're not a covered property, it doesn't mean that we still can't ask them, how do you know you're not a covered property? And so one of the questions we can ask is, do you have any rental units receiving assistance through a Section 8 voucher? Our client may not know if their neighbor receives a Section 8 voucher, but when I read that rule, I read it as saying that the entire property is covered if anyone in the unit participates in any of these programs. So I just wanted to point that out. I'm going to go back to the PowerPoint now. Just one second. So one of the questions we can ask, of the landlord is, do you have any rental units? And to the person who's there, we should ask them, how do you know this, and do you have personal knowledge? Are they a credible witness? I understand that someone has to submit that pleading, but it doesn't mean that we can't ask them how they arrived at that conclusion. Another way that we can make the landlord prove their case, whether they have the pleading or not, is asking about the federally backed mortgages. We need to know if the rental unit is in a property with a federally backed mortgage. And a very, very clear way of asking this is asking them, who is the mortgage servicer? If they can't answer that question, then how do they know that they're not a covered property? And the same thing goes for the lender. So there's two parts of the mortgage. It's your servicer and your lender, and either one of those can be connected to the federally backed mortgages. So it's really important to ask those questions. You can also ask them what websites they checked. Did you bring any printouts with you? What property address did you use? How do you know this, and do you have personal knowledge? I'm just going to point out that the rules of civil procedure for the JP courts do say that the rules of evidence don't apply. So technically hearsay is allowed, but that doesn't mean that if you're not asking this question in front of a judge, that the judge is just going to let it slide. If they go, oh, well, someone told me, how does that person, they should have to prove this, because these laws were passed to protect people who have lost their income through no fault of their own, and we should make sure that these laws are enforced. So I'm just going to show y'all. I looked up my house on the Fannie Mae website. And so in this screenshot, I've redacted my address, but it shows the address I used. Sometimes the tenant's address may not match the actual property, the leasing agent office address. Maybe the tenant's address is 1205 Main Street, but the leasing office is 1200 Main Street. If you just put in an address, if it's not matched to the right one, it may not come up, which is another reason why it just might be better to say, who is your mortgage servicer? Who is your mortgage lender? And I just wanted to point out that here it just shows that no match was found. If you do it on the Freddie Mac site, it doesn't even show what address you entered. And this is a search that I did for my own house on the MERS website. And I've only screenshotted part of the screen, but I just want to show, I had to enter my social security number. I had to say I was the owner of the house. And then down here, it shows who my mortgage servicer is. And it also shows who my investor is. The guarantor is Jenny Mae. Ginnie Mae this is a federally backed mortgage under the definition given by 4024, and it is not in that list I gave y'all at the beginning. And so that's why I just want to point out, if someone can't say who the servicer is or who the investor is, they really don't know if they're a protected property or not. And I really think it's important that people say how they know, when they checked, and things like that, because mortgagors are allowed to sell the mortgages. They're allowed to transfer to new servicers. And so this needs to have been checked recently. Who you start your mortgage with may not be who you have your mortgage with 5 years later or at the end of your mortgage. So it's really, really important that they're looking this up and that it's current information as well. So I said I was going to talk about mediation for just a second. If you know the time frame, a lot in Harris County in the JP courts, when most people are served with notice of their the eviction petition and given their trial date, it's generally about 7 to 10 days from the date they receive service. It can be up to 21 days according to the rules, but it's generally a really, really short time frame. According to the Texas Civil Practices and Remedies Code, if a judge orders mediation, they're supposed to give at least 10 days notice to people. There is a Texas Rules of Civil Procedure 503, I think 5, states that JP judges may order cases to mediation, but it also explicitly states that in eviction cases, they may not order mediation if it would delay trial. So it's unlikely that our judges will be able to order a case to mediation if a landlord doesn't already agree to it using a motion for mediation. The judges are allowed to do it sua sponte. If they want to order it before they set the trial date, they're allowed to. But I also just want to point out that whether or not mediation is court ordered, it doesn't mean that you can't request it with the landlord before the trial. The Harris County Dispute Resolution Center has agreed to make mediators available if landlords will agree to mediate. We've talked to them. They're working on gearing up in hopes that some landlords will try to work with people. We hope that the JP judges will order some people to mediation. The DRC is currently only offering virtual mediations because the building is closed to the public. They may or may not open it up for in-person, but right now they are virtual mediations and the services are free. And I just want to point out, if you do take a case, it is important to be cognizant of the appellate deadlines in the event that the tenant chooses to utilize their appeal remedy. I don't know if it's a remedy, but if they choose to appeal their case, there is a strict deadline. Like I said, they can use that statement of inability to afford payment of court costs or an appeal bond. If it is a non-payment of rent case, in addition to filing the statement, they are also required to pay rent into the court registry within 5 days of filing the statement. If they do not, the appeal still goes up to county court at law, but the landlord is allowed to request a writ of possession. And so it's very important that the tenant understands that if they are appealing and they want to stay in possession of the premises, that rent does have to be paid. And that's why we really want to help people. Oftentimes, if a person has a meritorious case, we can help them on appeal because they're not actually they're not having these rent payment problems. But for the people that have lost their jobs and can't get their unemployment or having other difficulties, this effectively prevents them from staying in the unit during the pendency of an appeal if they're not able to pay that rent, even if the landlord shouldn't have filed it. And so that's another reason why we're going into the JP courts now to make sure that the CARES Act is actually being followed. And I also just want to let you know that answers are not required in JP court, but they are required on appeal. You can e-file. It used to be that JP courts did not accept e-filing, but all of our Harris County JP courts do accept e-filing now. If you have a case through Houston Volunteer Lawyers, it's a free e-file. If you go to your payments account, you can add a waiver account, and you can use the waiver account if you're using a statement of inability to afford payment of court costs. A client can also appeal on their own by filing it on their own using e-filing or by going to the court to file it at the window. So I also have a few other helpful links here. The first one is a link to the main Harris County JP Courts webpage. They will have orders that apply to all of the courts on this page. At the bottom of the page, there's a link to each individual court. If you take a case, you should check both because sometimes the judges have specific instructions for their own court. Not everything is uniform from court to court. We wish they were. It would make it easier, but each JP is allowed to run his court or her court the way that he or she wants to. It's also great for getting the phone number, the fax number, and like I said, that court-specific orders. If you want to actually look at what's been filed in the court, this Odyssey portal link will you can see what's been filed in the JP Court and actually click on the documents that have been filed. If you want to see the JP Court daily dockets, there's a link here. And in the event you appeal and you go to County Court at Law, or you want to look at the real property records, there's a link to the Harris County Clerk's website. So I hope that everyone is going to commit to taking a case. If you signed up for today's email, you are going to receive an opt-out email. Please don't opt out. Please commit to being part of the pool of volunteers we have to take these eviction cases. Eviction, like I said, most eviction trials are set very, very quickly. By the time a person receives their citation and they come to us and we interview them, several more days have elapsed. And the way our process traditionally works, if you've worked with HVL before, is that we put people who have applied for assistance on a portal. And then the attorneys can look at the cases on the portal and decide if you want to take a case. Because these eviction cases move so fast, we're going to be sending out emails saying, we have these eviction cases ready to take, which one are you taking? You're not required to take one, but I really, really, really want everyone to commit to taking a case today. Like I said, you will be receiving an email. You can opt out. If you opt out, you won't be included in our pool. I also want to let you know we still have other landlord-tenant issues. If you're interested in reviewing those, you can go to the volunteer portal. The link is here. I also want to remind everyone that these materials are available in the volunteer portal. And these slides and forms are also available. I'm going to show y'all one more thing. Sorry, I just have the motion to dismiss. We're really, really, really trying to make things easy for you. And so give me 1 second to pull it up. So we have a motion to dismiss. Sorry, I don't think you can see it quite. We have a motion to dismiss already drafted. All you have to do in the event you're going to use this case, like take a case where we know that the property is a covered property, you have to fill in the caption. You're of course welcome to change anything you want. It has background about the CARES Act, and it has the information about it being their lack of jurisdiction. And we also have the assertion that it's a baseless cause of action. And baseless cause of actions under Texas Rules Civil Procedure 91A does include attorney's fees. We hope that you would request attorney's fees. If you're taking this case through HVL, it just gets turned over to HVL. It goes to our general operating budget. No one gets a bonus or anything like that. It helps our program. And of course, you fill in your signature blank. If you don't get normally your hearing is going to be your trial date. If the court doesn't set another hearing in here for your notice, you would just put your trial date. Of course, you have to serve the other party. By the way, these were also made for pro se litigants in the event we can't help someone. So in the event this seems not what you're used to, it's because it was made to be very, very easy for a pro se litigant to do. And then we have the order ready for the judge to sign. All you have to do again is prepare the caption. So I just wanted to point that out real quick. And these are things we're offering to you in the event that you decide to take one of these cases. So, questions. I'm going to go back to the comments now. I've been ignoring it for a little while, and I'm going to stick around for a while. So I'm going to stick around to answer any questions y'all have, and I'm going to try to keep up. So I'm going to scroll through a little bit Just 1 second. And if you want to repost it, I'll see it down here at the bottom. So I see that someone commented that she volunteered for the DRC and did a Zoom mediation yesterday, and it went really well. So thanks for letting us know that, Sherry. It's really, really great to hear that it went well. And so I'm still scrolling. And I just also want to point out, I see Eric Walters making some comments, and he is an attorney at South Texas College of Law, Houston. He is also helping people with eviction cases, as are other people around town. Lone Star is also helping people. The U of H Law Center is helping people. Thurgood Marshall School of Law, Earl Carl Institute is helping people. And we all have different availability to help different people. For example, we can help undocumented persons, whereas some of the other organizations can't. Lone Star helps people outside of the Harris County area, whereas Houston Volunteer Lawyers may not. They have a much larger service area than us. So just keep in mind that even though we want y'all to volunteer with us, that there are other options for people. And if anyone's coming to you to ask for help, let us know. Okay, I see a question about the CLE code for credit. I'm going to ask Brittany to email that to everyone who attended today. So I see a question that says, for a writ that was issued in March, the tenant lost the appeal in county court. She's indigent and now files an appeal to the appellate court. Okay, Eric's already answered that question. Eric's correct. They can move forward with the writ of possession. So, I see a question about, do we have input from our JP courts on how they're going to hear cases while keeping the public safe? I know that each judge is going to be handling his or her docket separately. One judge has told us that he used to hear evictions only on one day of the week, and he will most likely be spreading them out across the week in order to lighten the load. Instead of having a bunch of people on one day, there will be fewer people on other days. That judge also told us that he was thinking about having a system whereby people were encouraged to wait outside, where they could hopefully be in their cars or hopefully sit in the shade or something, and they would be called in to keep the group small. But that's going to be court to court, and if you have questions, you can call the court to ask. And that's the other reason why we have the virtual hearings and or the motion for a virtual hearing, if you can't just get a virtual hearing by calling the court. I'm hoping that the courts will be posting procedures on the websites about how you request a virtual hearing. The judges have asked that if you're requesting a virtual hearing, to please do it at least 3 days in advance. Okay, someone's also answering this question as well. The Patronella's Court was told that they're meeting to discuss how to handle the order and to call back this afternoon. If we hear anything, we'll let y'all know, but really the JP Court websites are the best place to check. So I hear that the CARES Act bars notice to vacate for any reason. I don't read it the same way. I read it that it's for non-payment of rent. That said, I do want to point out that just because a landlord files for something other than non-payment of rent, it doesn't mean that it's not a pretense for non-payment of rent. When I was poking around in the Montgomery County courts, and I saw that one apartment complex filed in 1 week 10 or so evictions, and they didn't. I can't see the pleadings, but I can see the amount of back rent owed, and it said 0 for all of them. That apartment complex is on the covered list, like one of the lists that you can do by searching that database. I find it highly suspect that they have a bunch of people that are current on rent that they want to evict. It makes me think that they're trying to circumvent the rule by not claiming non-payment of rent. But my guess is, if we could talk to the people who are being evicted, that they haven't paid rent and that they're finding some other excuse. That is another way that we can help protect tenants. If a landlord is trying to circumvent the law by claiming some other reason as a pretense for evicting someone when that person hasn't paid rent and that other reason is a bogus or made up reason or a far stretch of an imagination of a breach of a lease, that is another way that we can help, and we can point that out to the judge. But I'm just going to clarify, I still read it, the CARES Act, that it applies to non-payment of rent cases. I am trying to go through the list. If anyone's posted anything and you repost it, I will address it. I'm not seeing any more questions, but I'm still going to stick around a little bit in case you want to ask a question. Thank you, Craig. The slides are going to go out today, I hope. The other materials, if they don't go out today, they will be emailed to you later. And like I said, everything will be available in the volunteer portal as well. I really want to thank everyone for coming and attending today. And I'm again going to say, please, please, please commit to taking a case. Oh, and in case anyone was checking, the CLE code was posted. And it's 174085891. Someone's asking if you can watch it. This has been recorded. It's going to be posted on our YouTube channel, and I do believe that you can watch the first couple of minutes if you missed anything. And I am apologizing again for the delay and the technical issues in the beginning. It was my fault. I thank all y'all for attending. I hope that you have a great weekend, and I hope that everyone stays safe. The CLE number is in this chat, and I will repeat. Oh, it just got repeated again. 174085891. Thank you, Robert. Brian asked if the eviction filings are less than normal eviction filings. Yes, during the moratorium, even though landlords were allowed to file eviction, the number of eviction filings really did drop. They were a fraction of what they normally were. Like I said, it doesn't mean they weren't filing altogether. The number of filings, overall filings, did drop, but they're still being filed. I'm going to go ahead and end the stream. If anyone has any other questions, my email address is posted. My phone number is also posted. If you leave a message, I'll call you back. But email is generally the best place to reach me. And it's lisa.everett@hvlp.org, and it's on the last page of the slide.